this all leads to economic activity because it leads to productivity. That's what I say. Creativity, productivity, and that will lead to economic activity, and it's all interconnected like that. That's why I say it. Okay. So once again, thanks for the organizers for this bringing up this wonderful topic with a wonderful resource person, as I have seen from the big crowd who assembled here, and we look forward to hearing more and more from you, sir. Thank you.
Thank you, Sabu sir. Thank you so much. Next, we have the inaugural event. For the inaugural address, I invite our manager and faculty of our department, Reverend Father Biju Joseph Chakali.
Am I audible to you, ma'am? Is it audible?
Yes, Father.
Audible.
You may please proceed. It's audible.
Thank you. Respected Principal Dr. Sabuke Thomas, Chief Guest and Resource Person of the Day, Dr. Law Wellman, Professor, Government Law College, Calicut, Head of the Department, Dr. Sanathanan Villua, Vice Principal and IQSC Coordinator of the College, Father Anto Enche, Program Coordinator, Dr. Asha Matthew, teachers, and my dear students. It is indeed a great pleasure for me to be part of this webinar, as I too belong to the same department, Department of Economics. You all know that due to COVID pandemic, we all are forced to go with webinars these days. Lot of webinar sessions are organized by different disciplines, departments in our college on various topics. Today, the Department of Economics organizes a webinar on the topic Intellectual Property Right. As economics students, you may be knowing the concept of IPR, Intellectual Property Right, and what is the importance of it in the present scenario. Intellectual property right is a legal right that provides protection for our original works, inventions, our artistic works, scientific developments, and so on. The modern world, intellectual property rights have a significant influence on international trade and relations with the other nations. It increases the intrinsic value of all kind of goods and services. Because unique creations and ideas are becoming more and more important aspect of any business. The promotion and protection of intellectual property brings about economic growth. It creates new job opportunities and enhance the quality of life. Hence, in an economy like India, intellectual property plays an important role. In this context, the Department of Economics of St. Joseph's College, Devagiri, organized a webinar on this topic, which is gaining greater importance in the present scenario. I appreciate the organizing committee, especially the coordinator, Dr. Asha Matthew, and the head of the department, Dr. Sanathanan Villua, and all the esteemed faculty members of the department for taking initiative to organize such a relevant and wonderful session. Once more, my warm wishes for the program, and I hereby declare that this webinar on intellectual property right has inaugurated. Thank you. Thank you all.
Thank you, Reverend Father Biju Joseph. For addressing the gathering, I now invite our Vice Principal, the IQAC Director, and the faculty of our department, Reverend Father Anton Nellanguril.
Dr. Sabuke Thomas, our respected principal, Reverend Father Biju Joseph, our manager, Dr. Lowell Mann, the chief resource person of the day, Dr. Asha Matthew, the coordinator of the seminar, and my dear colleagues, research scholars, and my dear students. A very good afternoon to one and all. At the outset, I would like to thank Dr. Lowell Mann on behalf of IQAC for having accepted our invitation on a short notice, as he rightly mentioned, Principal rightly mentioned, for coming over here and to be the resource person of today's seminar. And his face is familiar to us because he has already presented a seminar, has come to our college to make a presentation on the topic, I think last year. So Dr. Lowell Mann is a familiar face to all of us, and I would like to thank for accepting our invitation. Incidentally, this morning while I was taking class for my second year degree students, I was talking about the ideas of capitalism. This is one of the schools of economics that existed in 16th century. So a school which focused, that gave more importance to trade and state intervention in economic activities. And those time, the government used to issue patents of monopoly to their companies, especially in Europe. It happened in Europe, in England especially. The patents of monopoly whenever they invented new products and processes. So the purpose was to take advantage in the international trade and to make favorable balance of trade. So we should keep in mind that it happened way back in the 16th century, and now I think we have to examine ourselves as being the citizens of our country, how far we have to go ahead in understanding, realizing the importance of the patents and how far we have taken advantage out of that. So I think in this context, I feel that this topic and more discussions on these topics are relevant for us as individuals, and is relevant for us as the citizens of our country, because when we can take more advantage on patents, our country can really definitely benefit out of that. And it is precisely because of this reason, even the accreditation and assessment agencies of higher education, they give more importance to the seminars and workshops on IPRs. That's why, so when they consider different seminars conducted by the colleges, seminars conducted on IPR and related topics. So this is in this context, the Department of Economics under the leadership of Dr. Sanadana sir and the coordinator Dr. Asha Matthew, and also along with that the IQAC actually decided to organize this seminar on this particular topic. So once again, I thank Dr. Lowell Mann, and also wish and pray that this may be a very fruitful session for all of us, for all the teachers, research scholars, as well as students. And wish you all the best. I remain. Thank you so much.
Thank you, Father Anto. The inaugural session is over. Now we move on to the technical session. To deal this area, we have a prominent persona, Dr. Lowell Mann P, a very unique name, which means a person who knows about law very well. He is an assistant professor in Government Law College, Calicut. He did his LLB from Mangalore University, LLM with IPR specialization from Cochin University, MA in Criminology from MS University, and PhD in Intellectual Property from National Law School, Bangalore. While talking about his experience, is an advocate and research associate, IPR, National Law School, CAIIB, Indian Institute of Banking and Finance, Mumbai, Assistant Legal Manager, Federal Bank, Legal Manager of Bank of Baroda, and much more. Lots of publications and workshops, which adds feathers to his crown. We are very much lucky to have this eminent persona. Now, I invite Dr. Lowell Mann to lead the talk on IPR. Now, over to Dr. Lowell Mann.
Thank you so much for the generous introduction by Dr. Asha. I moved, in fact. Thank you so much. Respected manager, respected principal, vice principal, head of the department, and coordinator of the program, Dr. Asha, other members of faculty, of course, the students who are other participants who are listening to the program. It's indeed my privilege to come to Devagiri. No, that says it all. I don't need to expand the name of the college. Such is the fame and name of the college, the autonomous institution. Now, and of course, it is, as I said, it is not my first visit on campus, offline. I was there on the campus dealing with some of the legal matters. I had a very warm time there, warm welcome, and I had a very nice time, enjoyed there. And perhaps this is the second coming or second visit to Devagiri, of course, in an online mode. So thank you so much for the invitation. It's my privilege. And congratulations for the wonderfully arranged prompt program. Now, coming to our topic, intellectual property rights. As head of the department, Dr. Sanathan was putting it. It is not new even to Devagiri. You had the privilege of conducting a program as early as 2006, having 100 participants, I'm told. I came to know that from his speech. Now, I'm here perhaps to talk on almost a similar topic, but perhaps from a different dimension. Intellectual property rights, to put it in simple words, in plain words, in flat words. Intellectual property rights are a kind of special property. It is a property, but it's a special kind of property. It has got certain specialities. And what we are going to do for the next 75 minutes or so is to understand the specialities of intellectual property and the importance of intellectual property rights, to make a basic sense of what it is. We will not go deep into it because it's a very vast subject. But let's have a glance at it. We will have a flip through the idea of intellectual property. Let's do that. My name, of course, it's discussed. Thank you for that. My name is on the screen now. My presentation is going to be my talk plus the slides. You are welcome at any moment to raise your hands or just open your mic and ask questions, or at least type it on the what you call the chat box. You can always do that. Let us make it light. Let us have that interactive session in the afternoon. So myself, I am Lowell Mann. I teach in Government Law College, Calicut. Of course, I've got some knowledge of intellectual property rights. That's the introductory I wanted to give, and let's move to the work. Now, I've got a few examples which I invite your attention to. Intellectual property is always connected with the intellect of a person. Intellect of a person. Because the innovative ideas take birth in the intellect of a person. And those ideas, when translated into useful products, you have intellectual property. Because you had the privilege of translating those ideas into useful things to the society. Let us look at some of the the possible examples. Let's look at a pharmaceutical invention which is so relevant now. A medicine or a vaccine for COVID-19. So important these days, right? Definitely there is investment behind it. Over and above that, there are a lot of scientists who put effort behind it. Those intellectual laborers who translated the idea of a vaccine to a product called Shield, which we use now, they require some kind of protection. They are being rewarded. That's the idea. Of course, it's based on science. There is law involved in it. Of course, economics is also there. So it's really multidisciplinary. Let us consider one or two other examples where you understand that this is something so connected with innovation. Now think of an automobile innovation. We Indians, whenever we go for a four-wheeler or a two-wheeler, the first concern, one of the priorities is what's the mileage, right? That's our question. Now think of a car which will give you mileage of 100 kilometers per liter. 100 kilometers per liter. Definitely it's going to have a good bucket, but definitely investment and intellectual labor will be there behind that. It's not only science that will matter, even cultural creations. Like just think of the third example I put, third wild thought I put now on the screen. Incremental culture. The right to publish Harry Potter. Of course, we would say that it's an addition to culture, but of course, it has a world market also. There is a lot of economics involved in that. So IP, or rather intellectual property, is always connected with intellectual labor and innovation based on that. Let's move with that presumption. Now, just look at the screen. I've got a tumbler, now it's empty. Let's fill it. I'm calling it as intellectual property system. I repeat, intellectual property system. And what we are going to do is, we are going to understand what's the content of that. The basic content, the subject matter we call it. What is that we protect as intellectual property? It comes from science and art. The examples I give, if you think of code, if you think of an automobile, it's all from science departments, if you think of a department. But it's not only from science department, arts department, something that comes out as copyright, will be from science and art. So the basic material, the basic subject matter for intellectual property right will be contributed by science or art, or science department or art department. So they also should be concerned about this. But that's not all. You don't sleep over those subject matters. What do? You try to commercialize it. That's where your department comes in, economics department, commercialization of that. So you have a very useful thing, Harry Potter publishing rights, very useful thing, very valuable thing. Or COVID Shield, COVID vaccine you have, it has got a lot of economics behind it. So what you're doing is a subject matter and its economic viability. Of course, useful to the society. So the second thing comes in, science and art plus economics, commerce. When you are dealing with such an important, valuable thing, you have to have, the lawyers, you need to have legal rules for that. So the third item in the intellectual property system is called legal rules. So it's really multidisciplinary, interdisciplinary thing called intellectual property rights. And perhaps there's a reason why government has made it part of syllabus of almost all the departments now. Not only law colleges teach intellectual property rights. Economics departments do want it. Commerce departments require it. And even engineering colleges do require it. So this is the system of intellectual property rights. This is the idea. And this is what we are going to expand on. I hope the foundation is laid. And let's move on with that. Now, when you keep on asking this question, when you keep on asking this question, what is intellectual property? Intellectual property is, in fact, it is not named for one kind of property. There are as many as 8 items. Please note, there are as many as 8 items included in intellectual property. So in our journey for the next 1 hour or so, what we are going to do is to understand and familiarize ourselves with all the items of intellectual property rights. Let us list that out, then we will just discuss that one by one for 10 minutes or so that our session will be over. Let's do that. Let's list that out first. Patent, perhaps it is the most discussed one. Patent could be the first in the list. And of course, you have trademark also coming in. You might have come across that. And industrial designs is third intellectual property right. And fourth one is copyright. Perhaps I would say this is the most popular intellectual property right. Even if you are not familiar with the area, you must have come across, you must have heard about copyright. Then you have semiconductor chip protection, but a little bit of technicalities involved, but of course it is also important. Then you have plant varieties, where biotechnology department or principles department should also be concerned about. And then you have GI, that is nothing but geographical indication. For short, you have GI. And obviously, not the least, you have trade secrets. So this is going to be our journey. That's the reason why I put it on a screen. I have put it on a road. This is going to be our journey. We are going to make sense of all the 8. Of course, we are going to have an overview of that. I hope all of you are ready for the journey. Let's do that. Thank you so much for listening to me so far. Let's move to the first item in the list. What's the first item? Just have a look at that. The first one is patent. I'm just giving you a context with the picture. Now, Sanathanan sir is giving some. Of course, I think it's not concerned with the content of it. Of course, there are some 50 people waiting for that. Okay. Right. Just have a look at this picture. You can identify. I don't want to test your GK. You will identify the instrument, the invention. You will identify the inventor. Now, this is a breakthrough in the history, right? It made our life very different in the form of mobile phones now. Even earlier it did. Now, it's not just these kinds of inventions that would matter and that would come within the fold of intellectual property rights or within the fold of patents. Inventions for the purpose of patents, patent law, intellectual property law, could be very simple also. Let's have a look at another picture. Just look at the chronology, look at the gradual development, the way in which it was graduated. It was just simple rock. Then it is a stool. Then another development, it has got a back. Now a better chair. Then you have a rounding chair. This is something which I'm sitting on. You can see that. And you have another better one, and you have something with hand rest also. So this is the development. I'm trying to make 2 points with these pictures. One, a patent, an invention for the purpose of patent need not be a breakthrough in the history, as in the case of Edison's invention. It could be as simple as this, if I can borrow some words from Suresh Gopi. It could be as simple as this. And another point I'm trying to impress upon is it could be incremental. It need not be an altogether new thing. A stool to chair. Stool is already there. A stool to chair is an incremental innovation. That particular part is an innovation. a chair to a revolving chair. Of course, chair is not protectable, but that revolving, that mechanism could be protectable. So 2 points. It could be simple, it could be simple technology, it could be incremental. I think point is well made. Let's move on with that. Now, patents can take 2 forms. Patents could be either product patent, as in the case of a bulb, as in the case of a tablet, as in the case of a medicine, as in the case of a chair. It could be a process also, a process of making something. Now think of something, think of a medicine which is already existing, but the way in which it is made is very expensive and cumbersome, and the manufacturing process is so problematic. And if you are coming out with, or if you as an innovator coming out with a new manufacturing method wherein it is less expensive, less cumbersome, and so easy. So you have a technologically innovative process available, and that is also an innovation. That's also an invention for the purpose of patent. And patent law says if you have such a method, that is patentable. So that is what process patent is. That's a basic difference. Of course, it's not that very simple, but I think that will give you a basic sense of what process patent is and what product patent is. With that understanding, let's move. So just look at the qualifications. We said inventions are protectable under the patent system. So what are the qualifications an invention should have for the purpose of having a patent? Qualifications of a patentable invention. That's a question we are just trying to make sense of. Any product or process it could be. It could be any process or product. And obviously it goes without saying, it should be new. Novelty. Novelty is one of the first requirements, and that goes without saying. But it's not that very simple. It is throughout the world. Just think of now how it is going to be assessed. But let's stop there and understand that novelty is one of the requirements. But novelty by itself is not sufficient. There is an additional requirement. The second requirement, which is on the screen now, let's have a look at that, which we can call as inventive step. A novel, a new thing, without a technology involved in that. Just think of a bucket torch. I'll repeat it, a bucket torch. Have you come across that? I expect some response on the chat box. Have you come across a bucket torch? You might not have. It's definitely something new. But a bucket torch, yeah. So Nathan said, thank you for the response. Of course, I hope your students will follow. Bucket torch is something new, because nobody has come across that. I have never come across that. I'm almost sure that none of you have come across that. But that is not patentable because there is no new technology involved in it. There is no technological step forward. There is no inventive step forward in that. It is just an adjustment novelty, I would say. A workshop improvement, I would say. But now look at the pictures on the screen, the bulbs you have. You have 4 bulbs there. You have an ordinary old bulb. You have a little modern bulb. You have a CFL and you have an LED. Now feel the difference. A bucket torch is much different from this. This is novel, but it is novel. It is novel with inventive stuff. There is a lot of technology involved in this. So your requirement, our requirement for the purpose of patentability is technology-based novelty. Then it is patentable. That's a requirement of a patentable invention. Now look at the third requirement. There is another one, industrial utility, which we can, for short, we can call it as usefulness. An invention which is useful only can be patented. A positive use. For example, a person comes out with a machine for burglary or robbery. Locks can be opened very easily. Perhaps it will be new. Perhaps it will involve inventive step, but definitely even though nevertheless it will not be patentable because it will not have a positive utility. It cannot be sold in the industry. So such a thing is also a problem for a patentable invention. So an invention to be patentable should be new, should have inventive step, technology, and a positive utility for that. These are the three requirements for a patentable invention. So we are just laying the foundation for our intellectual property understanding. Let's move with that. Now, there is something known as patent search. I won't speak much about this because patent search is nothing but a search to ensure that the invention for which you are granting patent, you in the sense the patent office, granting patent is in fact new. That's a process to ensure that patent search or novelty search, you can call it as. And usually the inventions and the patents will be classified into different departments. I put the names of that just to give a sense of that. And patent is not much related to law and arts. In fact, the patent department is full with science people. The minimum qualification is MSc or BTech. Definitely you can try for that. There are different departments like this. And the patent search will be conducted mainly in the database of these departments and of course other databases also. I just wanted to give you that sense. So there is something called patent classification and patent search. We don't want to dwell deep into it, but let's have a basic idea about it. Now, and a point I would like to emphasize on, which is available on screen now at the foot, is in order to be patentable, an invention should be registered. If you invent and if you just use it, you perish. If you invent and if you patent, you can prosper. Registration is a compulsory requirement. Unless you register the invention, there is no patent for that. You can use it, anybody can use it. You don't have the exclusivity for that. To have an exclusivity, which we can call as property right, you need to have a registration for that invention. Of course, a registration process is a techno-legal process, which is a bit complicated thing, which we are not going to dwell deep into. Let's just ask a question. Who can apply for that? Who can apply for that? I've got a picture, which of course you will recognize. I'm sure about it. Who are the three category of people who can apply for this? True and first inventor. The person who has invented the thing, it can be definitely, he can make an application for patent. And assignee is a person who gets it assigned, transferred from the inventor. And legal representative could be the legal representative of inventor or assignee. These are the three category of people who are recognized under patent law for the purpose of who are entitled for application. And the scientist on the screen is definitely one of the best examples you have who could make an application, who could have made an application earlier. Let's move on. Now, what are the benefits you get? Once you register, once you get a patent, what are the things you get? What's the benefits you get? What's the privilege you are going to have? Called patent. You will have the right, legal right, which I would call as commercial right or business right. You will have the right to manufacture the patented product. You will have the right to use the patented product. You will have the right to sell the product, import the product, export the product. And please note, mind you, this is going to be an exclusive right. You can use it. Nobody else can use it. If somebody uses it, then definitely you can stop it with the assistance of law. So this is a kind of exclusive opportunity to recoup the cost and make profit. By the way, I hope the participants won't mind me asking a question. Is monopoly good? A question to the economics department. Is monopoly good? I expect a response, please. No. Swati says no. What do you say so? No. Sanathan sir also says no. Thank you, sir. Thank you, Swati, for the response. Monopoly is bad. That's our social sensitivity. But if we get it, if we are getting exclusive right, a monopoly for a definite period, only we are there in the market. You are getting a business right. Nobody else is there. And if somebody comes in, then you can stop that person. You get monopoly right called patent in the market. So patent is a legally sponsored, legally protected monopoly. Enjoy that. But as Swati said, as Sanathan sir said, monopoly has problems. We know that. So monopoly is not indefinite. When you think of patent right, the duration of patent right is 20 years. So the idea is this: if a company comes out with something useful, a new machine, for which there is a lot of investment gone into and a lot of intellectual labor gone into. So this is a kind of what you call a kind of incentive or reward for that. For 20 years, if you're coming out with something new, you will get a reward for 20 years, a monopoly for 20 years. Not 24 years, 20 years only. But in 20 years, you are the Sultan, you are the Raja. That's how. And this is covered under Patent Act 1970 in India. And the thing is, by this, patent law is incentivizing innovation by private companies and private people and even in government sector, anywhere. So this is an economic instrument called law, legal instrument, to have more and more stock added to the knowledge stock of mankind in general sense, in a theoretical sense. So this is a basic understanding of patent. If that is laid good, let's move to the next item in the list. Can somebody remember the next item in the list, please? No response? Yeah, Jasmine Rath has a response. Now I've got a, yeah, thank you everyone. Thank you Khadija. Thank you Sri Lita. Yeah. Now, do you recognize this? Just look at the screen. Just look at the screen. Do you people recognize this? Give a response, please. Do you recognize? Yes. Swati recognizes it. I think all of you will recognize. Lakshmi Priya recognizes. Khadija does that. Vishnu Priya, Renu, Fatima. There are very many. I think almost everyone is going to recognize it. Just have a look at this. So when you come across this thing, what is that you are reminded of? This is a kind of trademark. In simple words, in a more popular word, it's a brand. Look around you, look at your body, you are a brand ambassador. Your dress will carry a logo, your mobile phone will carry a logo, your chappal will have one, your laptop will have one. Look around, you're all brand ambassadors. Now, when we come across such a thing, what are we reminded of? Let us just take a list of that. This particular picture represents a product or a service. I need not tell you what it is. You people are aware of that. And it shows the source of the product. We know that it comes from the source called Apple company. You may not know the postal address of Apple company, but you definitely know that it comes from Apple company. And it has got the ability to distinguish. When you see this on an iPhone, you understand this is from Apple. At the same time, you also understand that it is not Nokia, it is not Samsung. You also understand this is not another company. So it has got the ability to represent a company and its product and its goodwill. And at the same time, it can distinguish also, which is very, very, very important in a market situation. Because every company wants to project all the products, Allah. What it requires is, it wants to project its product only, because it's very selfish. Capitalism is selfishness, I would say, in that sense. Now, for that purpose, you require something, a mark, something which will represent your company only, and which will distinguish, which will keep your products distinctive from others' products. For that purpose, this is a wonderful tool. Just look at that once again. And what else does it show? It shows quality. Just think of Nokia and iPhone. Just think of Benz and Nano. It's not that one is good quality and other is bad quality. This is two segments, different quality it represents. And it is an advertising tool. Just think of tomorrow if you are telling Tata, don't use the word Tata. They are going to perish. They are going to perish. So any advertisement for a company, this is an inevitable thing, advertising tool. So all these things, all these qualities, all these things put together, we can call it as goodwill. So a trademark represents goodwill, and the value of the trademark, the intellectual value of the trademark, lies in the goodwill of that trademark and the company it represents. I think that point is clear. Now let's move on. I've got a what you call a picture, or rather a kind of a schedule kind of thing. This is a kind of ranking by Forbes magazine. You must have come across Forbes magazine. You must be knowing about it. What Forbes magazine did 2 years back, or 2 to 3 years back, was they made for a ranking of world famous trademarks. So they went for a 500 trademarks. They made a list of first 500. They made a short list. Then they ranked it. And what is on screen, please make sense of that. What's on screen is the first 10 trademarks. Just look at that. Apple, Google, Microsoft, Coca-Cola, Facebook, Toyota, International Business Machine, Disney, McDonald's, and General Electricals. There are very many things to be understood in this. One of the things I would like to invite your attention to is how many are Indian. Can you just point out any one from India? Definitely no. How many are Americans? How many are American companies? These are all multinational companies. They are doing business in America. They are doing business not only in America, they are doing business elsewhere also. The WTO context. They need not, there is no much border restrictions. They can take home the revenue they generate in different countries. So the idea is clear. When you have good trademarks, which means that you have a strong company and you're doing business and you're taking money home, and this is one of the indicators of the economic prosperity of a nation. I don't say that that's the only criteria, but this is one of the criteria. Now, what I wanted to invite your attention next to is, just look at Apple. And next to Apple, you can say Apple written over there. If you're using mobile, it may be a little difficult, but have a look at that. And Apple is rated at, the value of Apple is $154.1 billion. $154 billion. And what's the sense of billion for us? For me, billion is 9 zeros to the digits on the right side, definitely, right? And now to convert that to the Indian rupee, you need to multiply that with 75 or so. What could be the figure? I calculated it, and the figure is on screen. Just have a look at that. I don't want you to remember this figure. There is no use in that. But definitely, I wanted to convey the message with this figure. It's a big figure. It's a very big figure. It's a mind-boggling figure. And perhaps in terms of money, this is the most valuable single item in the world. And mind you, this does not include the value of any of the tangible items like car, mobile phones, or anything of that sort. This is the value of mere goodwill the company Apple represents. Nothing else. Pure goodwill. Intangible thing. The good name it has. So that's the value of that. Perhaps in terms of money, this is the most valuable single item in the world, on earth. So it's so valuable. Let's move on. So the next question is, what can be used as a mark? There are very many things which you can see. A word like Tata could be trademarked. A letter like T could be trademarked. L like Leyland could be trademarked. Or a logo which you have on the screen could be trademarked. Or it could be a numeral 555 or 7up, which is a possibility of trademarking. and of a drawing on a picture, Kentucky Fried Chicken, KFC, or like a label which you stick to or which you stitch on, are trademarkable. And if you look around, you get to see all these. Perhaps you are using some of these products, wherein you have all these trademarks. These are all traditional trademarks, conservative traditional trademarks. But I've got a list which will be more interesting. Just look at this picture, look at this picture, look at this bottle. If you go for a close look at that, you can see that Coca-Cola is written over that. Coca-Cola, the word Coca-Cola is a trademark. It goes without saying. I don't want me telling you that. But the shape of the bottle is a trademark, because when customers perceive the shape of the bottle, even without seeing the word Coca-Cola, they are recollected of the company called Coca-Cola and its product. So the shape of the bottle has a capacity to represent the goodwill of the company. If it has the capacity, if anything has the capacity to represent the goodwill of the company, then it's a trademark. That's the very essence of trademark. Let's make a list of that shape. There are very many examples you can think of, and ordinary examples where it is life, even in India. Sound. Just think of a sound. Can you just give an example of a sound without giving the name of the sound or naming the company? If you're reminded of the company, just because of the sound. Just think of that. Just give an example, please. What about Airtel? Will you be reminded of Airtel when you come across that, Airtel music? Similarly, you can have color. You can have smell. What could be a best example for a smell trademark? I think the best example could be nothing but our Dettol. The best example, because even without seeing Dettol, when somebody brings Dettol to your nose, you're reminded of the company and the goodwill. Then taste, packaging, moving images, it could be. So anything of this sort could be what you can call as non-traditional trademark. These are also trademarks. That's a point I'm trying to make. Now look at this. What is this? Can somebody put that in the chat box? What is this? SBI. Jason says SBI. But please note, I think there are hundreds of people, all the participants who are going to say this is SBI. But please note, nowhere it is written on the screen that it is SBI. This is this criterion. We don't require any further explanation. A mark, a blue colored, what do you call coin, keyhole, has become SBI representative. In 1955 or so, when SBI was established, I think this does not have any meaning. At the most, it had a keyhole meaning. Now, over a period of time, perhaps because of the experience, perhaps because of the the advertisements, the sponsorships, the more publicity, the people have started attaching this particular thing with SBI, or rather, this has become a trademark from a mere mark. This is a process of trademarking or a mark to trademark process. That's the process. Let's move on with that understanding. So how to get legal protection? You have two ways. Unlike patents, in the case of patents, registration was compulsory, but in the case of trademark, it is not compulsory. You can have a registration way. Of course, if you register, you get a protection. But even without registration, if you can show goodwill, if you prove goodwill in the market, then you get an unregistered protection called passing off. Let's move on with that. Then when you usually register, or whenever you get a trademark, right, you get a trademark in relation to a set of goods. The total goods and services are classified into different classes. Class 2 is on screen. Just have a look at that, just to give you a sense. Did not remember all this, but look at another one. This is another class. So Asian Paints might have registered in class 2, which means that they have got right, they have got trademark right, they have got that goodwill, and they will have the exclusive right to do business in that particular area of business, in that particular class. That's the understanding we need to have. So the duration of protection is another question. What was the duration of protection in the case of patent? Just try to recollect. It is 20 years. But in the case of trademark, it is unlimited protection. If it is registered, of course, you should have the formality of renewing it. So it goes on and on, unlike a trademark. It is unlimited protection, perpetual protection. Now let's move on. You have a trademark right, either registered or unregistered. What's the advantage you have? I put that in the form of a right, a legal right, on screen. I've got the rule for you to read on the screen. Just, it is a right. The owner of a trademark will have the right to prevent use of identical or deceptively similar trademark on similar goods or services. So you have the right to use the trademark, and you have the right to use the trademark on a particular class of goods, a particular area of business. If another person uses an identical or deceptively similar trademark on a similar business, then it is trademark violation. You have the exclusive right to use this in the business. That's the idea. Let's have a picture on screen. Let's look at the picture on the screen. Just look at the picture. Are they one and the same? Are they one and the same? Are they one and the same? I expect an answer here, because this is something which should be communicated. The first one is Sanathan says no. Sanathan says no. Home lights, and the second one is home lives. Agla says so. Swati says so. And this is what deceptive similarity is. We people, of course, you are PhD students and members of faculty. We are sophisticated customers. Even we might be confused with these kinds of similarity. Of course, if we are going for a very close look, we can understand that one is home lights and another one is home lights. But that's not the matter. It is likely that instead of home lights, you might purchase home lights from a supermarket. You may pull out. So here what happens is, instead of home lights, if you're purchasing home lights, you are making use of the goodwill of home lights, because the customer thinks, or customer is confused with home lights. The home lights has the goodwill, and that goodwill and related amount revenue, that purchased revenue should go to that particular company. That is snatched away by the second company because they are using something similar. So this is an example for trademark use and trademark right. Home lights and home lives. And now look at the second one now. So at the same time, what we need to understand is, are these trademark violation? If I can have a response, is this a trademark violation? No, Lakshmi Priya says so. Albi John also feels the same, and that's right too, because we know the rules. Chandriga soap, that's a cosmetic item, and Chandriga is excuse me for that. Those who not know Malayalam, please don't mind. This is Chandriga newspaper. So these are two different areas. So it's not trademark violation. The trademark right is confined to that particular area alone. Let's move on with the understanding. Now, I hope all the participants would recognize this. It is the legendary Mercedes-Benz. Now, I've got another picture which I want you to compare. Just compare this. Are there trademark violation? It's a composite mark, I would say. There is logo, there is color involved, there is of course there is words involved, and many of you say that it is no. As per our discussion so far, it's right also. But the second product is an undergarment, a textile item, I would say, underwear. And this is a Bombay High Court case in this area. Now what happens is, in this particular case, what you said would have been the decision of the court. Definitely, we were following the earlier rule of trademark, ordinary trademark. Because the area of protection is limited to a particular area of business. But when it comes to well-known trademarks like Benz, that's the point I'm trying to make here. Please note it. So as this is a well-known area of trademark, that is well-known trademark called Benz, they have got a wider protection. Their area of protection is not limited to a particular class or particular area of business. They have got a wider right. So if you're selling even vegetable in the name of Benz, they can just stop you. So the rule is this: in the case of ordinary trademark, your right is limited to a particular business area, and in the case of well-known trademark, the area of business is unlimited. There is a limit for that. So with that understanding, so what you can say is protection is there available against use on dissimilar goods and services also. That could be our understanding, a formal understanding. Now let's move. With that, we complete our discussion on trademark. I hope you have a basic understanding of that now. We are moving to the third one in the list, as per the first list, list on the road. Now, just have a look at this. This is, you are in a crockery shop, in a supermarket. And two conditions here. Each item is priced at ₹100. And each can contain ₹100 milli of that particular liquid. 100 ml of that particular liquid, whatever it is. It could be tea, it could be snacks, it could be anything, it could be juice, anything. So price-wise, function-wise, there is no difference. Which one are you going to purchase? Which one are you going to purchase? You would be purchasing something which is appealing to your eye, because price-wise, function-wise, there is no difference. So my point here is, I've got another example, and that is a ladies only example, but gents can also have a look at that. Just look at this. Gold is priced the same. Each day there is a price. The only difference is the making charge. How do you select one from this? If I can ask Agila, Agila was one of the names it just came up. How do you go to select? You are going to select one looking at the design of that. So design has a major function. Just look at any of these items. In jewelry, it has a function. In the case of sarees, there are designer sarees, toys, mobile phones, automobiles. In almost every sector, it has a function. So industrial design is also an intellectual property, which will make a lot of sense. Then you cannot functionally, you cannot price-wise differentiate the product. So in a capitalist market where there's a lot of competition, this is an invaluable tool, and this also originates in the mind of a person, in the mind of a person as an idea which they translate onto a cloth, onto a product. So you have an industrial design wherein you have shape, configuration, color, lines, etc., etc. coming in. So the point here is industrial design is also an intellectual property. Now let's go for the details of that. I don't want to spend a longer time for that. Now we have the same pattern, new and original design. It goes without saying, only new and original designs can be protected, and the right you get is the right to prevent unauthorized use. Without your authorization, you get some exclusive right to use that in the business, and registration is compulsory like patent. Without registration, there's no protection, and duration of protection is 15 years. Again, there's a comparison with patent. In the case of patent, it was 20 years. Here it is just 15 years. And the law dealing with designs in India is Designs Act 2000. These are the basic details about designs, which we had a very fast travel in the area of business. Designs. Let's move to next on the list. The fourth one on the list, if you have the list, is copyright. Just look at that. In order to get copyright, you should prove, you'll have to show to the court, or you'll have to show to the copyright office that your work, that's a terminology we use, your work includes in any of these categories. It could be either literary work, or it could be an artistic work, it could be a dramatic work, it could be a musical work, it could be a sound recording, or it could be a cinematograph film. So it could be any of these. If you have any of these creations, cultural creations, then you get copyright protection. Now let's expand our idea, expand our thinking, expand our understanding. Let us just look at this. Is this a cultural product? Is this the literary work? I'm sure that the answer is going to be yes. There is no doubt about this. But if I put this as an example, is this a literary work? You definitely going to have a doubt on this, because usually we don't categorize this as mathematics textbook as a literary work. But the idea of copyright is not only to protect literary work, but also to protect any kind of literary effort, any kind of intellectual effort. So now the present question is there intellectual effort behind mathematics textbook? If the answer is yes, definitely there's a possibility of copyright. And if the next question is if there is investment by the publisher to publish this work, yes, it is there it is there behind a mathematics textbook also. So intellectual effort and investment, both are there behind a mathematics textbook. Then definitely it's also a copyrightable item as a literary work, though it is not literary in the ordinary sense. It is the legal sense. So anything in print and writing, it could be book, it could be letter, it could be question paper. Just look at the screen. It could be answer scripts, it could be abridgments, it could be compilations, encyclopedia, dictionaries, and plus have to look at the last item. Even a software is a copyrightable item. Please note that. Now let's move to the next item in the list, that is artistic work. This is definitely an artistic work. Let's look at the list and go faster. Painting, sculpture, a drawing, a diagram, a map, a chart, a plan, engraving, and anything in the list, whether or not such work possesses artistic quality, then definitely it is an artistic work, if there is intellectual labor behind this. Now let's move to the next, dramatic work. The first thing that comes to your mind, our mind, will be something like this. A drama which is, wherein you have a scene-by-scene arrangement, could be the dramatic work which you have in your mind. And that's right also. Drama could be recorded, drama could be written also. But in addition to that, I invite your attention to the third item, the screenplay, which is related to a film. A film screenplay is also a drama for the purpose of dramatic work, for the purpose of copyright. So please note that, just add to your thinking, add to your understanding. Let's move further. Musical work. In the case of musical work, we need to amend or modify our understanding. Usually, when we see musical work, the usual understanding is that of what you call a film song. But a film song is not a good example for a musical work under copyright law. Under copyright law, musical work would mean a music that is produced from an instrument or a group of instruments only. The best example I can give is that of Airtel. In Airtel, you have only music, nothing else. Nobody is rendering it. There is no lines involved. So that is a pure musical work. And the next item in the list is sound recording. And sound recording is the best example for a film song, wherein you have Kishore Kumar singing it, you have music by somebody, and you have Javed Akhtar giving the lyrics. So lyrics are there, then rendering is there, then of course you have got music also. A composite thing called sound recording is another example for copyrightable item. Let's have a look at this. This is a composite work. Now the last item in the list, that is cinematograph film. Cinematograph film is definitely a mixture, an avial, those who understand Malayalam, an avial called avial of copyright, wherein you have all the composite things. You have got different ingredients going into it. You have got stories, screenplay, and dialogues. Story would be literary work, screenplay and dialogue would be dramatic work. You have lyrics, again, literary work, musical work, and you will have film songs wherein it is sound recording. You have acting, you have videography, everything going into it. So it's definitely a mixture of that. So it's a composite work. That's the idea I'm trying to convey to the esteemed audience. Now, another thing I just wanted you to add to this list is a TV serial. A TV serial also has all these items in its list. It also has a story, it also has a screenplay, it also has videography, lyrics, all those kinds of things. So a TV serial even is a film for the purpose of copyright law. So a TV serial, a film, a documentary, a TV advertisement, anything of this sort could be a cinematograph film for the purpose of copyright law. It could be a copyright violation then. Now, let's look at the author. Who is the author of a copyrightable thing? In the case of literary and dramatic work, it is the author, as we understand. In the case of musical work, it is the composer. In the case of artistic work, it is the artist. In the case of photograph, it's photographer. But the thing I wanted your attention to is the thing now on the screen. Just look at this with some animation. In the case of film and sound recording, it is producer, please note, and not the director, not the screenplay writer. That is the monetary and the bias of copyright law. And in the case of computer generated work, it is the person who has used the computer who is going to have copyright. That's understanding. Now, let's move on. Let's move on to this. This is about term of copyright. In the case of patent, it is 20 years. In the case of design, it is 15 years. Let's see what's the rule in the case of copyright. In the case of copyright, in the case of published literary, dramatic, musical, and artistic work, the rule is on screen now. It is the life of the author plus 60 years. I hope the rule is clear. It's simple. I've got a question which I hope you will give an answer to. Is this book copyrightable now? Is this book copyrightable now? I expect an answer. I expect a response. And Lakshmi Priya says yes. Swati says yes. Agila says no. Agila, could you just speak out if you don't mind? I hope you don't mind. What could be your reason? Agila is right there. Don't think otherwise. Here we know the book, we know the author. We know that Gandhi died in 1948. So life of the author entered in 1948. And we need to add 60 to that. It is 2008. So the meaning is from 2009 onwards, there is no copyright. Copyright expired. So anybody can print and publish. And that's the reason why, please look at the screen. We have got Penkin also, publishing the same. Originally, it was a Gujarati publication. And look at the another copy. Look at another copy. If you walk into a DC book shop in Kerala now, today, you definitely come to come across their own DC books on my experiments with truth, because there is no copyright existing now. So intellectual property makes a lot of difference. Till yesterday, if copyright was there, if patent was there was an exclusivity. There was a monopoly in the market, and you are losing that the very moment you lose your intellectual property. That's the point I'm trying to convey. Now, you have got another rule, rule 2, in the case of term of copyright. In the case of photographs, cinematograph, film, sound recording, etc., it is year of publication plus 60 years. From the year of publication, 60 years. There's the second rule as far as copyright is concerned. So these are the two rules as far as copyright term is concerned. Let's move on, and I request that all the participants please do read this sentence. The sentence starting with any person. Please do read it. Any person who knowingly makes use on a computer of an infringing copy of a computer program shall be punished with imprisonment for a term which shall not be less than 7 days. which may extend to 3 years. And please note, you need not make a new software. You need not copy a software. If you are using it, knowing that it is pirated, that's it. It is a criminal offense. Just knowledge that this is a pirated thing. It is not required that you make it. It is not required that you copy it. Nothing. The only requirement is that you know that it is pirated. It is a criminal offense. Is there anybody who can say that I'm not a criminal under this law? Including members of faculty. I can raise my hands. I've used pirated. But law, there is a law. I am. Sir, perhaps you are the one among the very few people who never used it, or now you are not using it. Sanathan, sir. Okay, I am. Okay. Now, but there are some exemptions. The law says if you are not using it in a commercial sense, then the court can exempt us. And perhaps this is the reason why Microsoft is not coming out with a case against us. Perhaps that's the reason. Let's move on with that understanding. Be careful. And now we are moving to the next item in the list. This is about integrated circuit layouts of semiconductor chip protection. Let's move faster. We are going to take a few minutes only on this. New and original electronic items. Innovations in the area of electronics. That's what integrated circuits are all about. List is there. You've got a lot many examples. You've got there is no dearth of examples for this, and intellectual labor is there behind this, and there is investment going into this. Then this is intellectual property. Let's have that understanding, and with that understanding, let's move on and have the basic ideas about it. New and original layouts are protected. Now, if registration is compulsory, the same pattern we have, and duration of protection is just 10 years. In the case of patent, it was 20. Here is just 10 years. And the law, the name of the law is on the screen. The Semiconductor Integrated Circuits Layout Designs Act 2000 is the law dealing with this particular area of intellectual property. It's a short look at that. With that understanding, let's move on. Let's move to plant variety, something related to biology and biotechnology. Put it in simple words, it is technology in biology. Of course, the people, even if you don't belong to biology department, you would recognize this person, Gregor Mendel, the father of genetics. So I would say, I would present it in this fashion. In Kerala, one of the major problems now we face is there is no proper people to pluck coconuts because it's up on the coconut tree. So what we did is we just brought coconut tree down. We have dwarf coconut trees. And usually coconut tree used to give yield in 10 years or 8 years to 10 years. Now we have new variety of new biotechnology, perhaps modified products wherein it will give yield in 3 years. So you have a new variety of a plant which has got a different feature and a different performance. This is made possible because you used technology in biology. I hope I'm making sense. Technology in biology, and you are coming out with something new which never existed in the nature, and you are solving so many problems. It's useful. If that is the case, then you are entitled for protection. There is intellectual labor going behind this. There is investment in this. Then you get plant variety protection. But please note, this is not exclusively for a breeder or a technical person. It's available even for an ordinary farmer who has got his own method of modification. So we have got two rights under this: breeder's right and farmer's right. Both are intellectual property owners. Both could be. Now let's go for the further details on this. It should be novel. The dwarf and the coconut tree you have should be novel, and it should be distinctive. Its feature should be distinctive from the other things. Should have uniform features. All the coconut trees should have the uniform feature, and it should be stable. In the next rowing also, it should have the same. If you plant it again, next generation also should show the same quality. So these are the requirements of a plant variety which is entitled for intellectual property right. And duration of protection is from 15 years to 15 to 18 years. And the law dealing with that in India is a 2001 law, which is available on screen. The Protection of Plant Varieties and Farmers' Right Act 2001. This is the law dealing with that. Let's move further and finish it off. We have got 2 more items to go. Just look at the screen and look at the picture, which will be a lighter way of looking at things. This is Aramula mirror. Everyone would know that. This is Darjeeling tea, and this is Mysore sandal soap, and this is a liquor, Scotch whiskey. And the question I have is, what is common in all this? What is common in mirror? What is common in tea, soap, and Scotch whiskey, a liquor? Definitely, as Akhila said, it is a geographical indication. As Jason says, it is a location. So, an ordinary mirror is very different from an Aramula mirror. Its quality is very different. Pricing is very different. It makes a lot of difference in the market. And ordinary tea and Darjeeling tea are very different. Whiskey and Scotch whiskey are different. People say so. We do not know. So, there are geographical names having commercial value. And if you have a geographical name having commercial value, all the people who make the products of this geographical name will get protection of that. So this is a group right you have. This is a group right. Please note that. So let's look at some of the examples here. Let us look at jasmine flower, mullapu. This is a Tamil Nadu example, Madura Mallige. Just look at it. It goes like this. It is a study conducted by somebody. Let us just simply understand it. We won't spend much time on it. As far as this particular thing is concerned, Madura Mullapu is concerned, fragrance is the highlight. Fragrance is the highlight as far as any jasmine flower is concerned. And people say usually it is for 24 hours. And if you don't have a jasmine flower, if you have a jasmine flower without fragrance, it goes. For commerciality, its smell is so important. And please note, instead of 24 hours, the Madura Mallige would last for 36 hours. Its fragrance would last for 36 hours. And a product for which the only life is 24 hours, and if it is extended to 36 hours, then it makes a lot of difference. And it is said that it is made possible because of the laterite and reddish soil available in Madurai. So it's a distinctive feature. It's a geographical indication. Now look at the petals. And jasmine flowers are not used in single. The garlands are made of it and it is transported. So for these commercial purposes, if you have a stronger petal, then definitely you have a better garland and you can transport it better. Definitely it makes commercial sense. And as far as color is concerned, of course it's subjective, but the color goes on changing as far as Madura Mallige is concerned. And the freshness. As far as the flower is concerned, freshness is of utmost importance. Usually, jasmine flowers, ordinary jasmine flowers, bloom around 5 o'clock. But it is understood from this study that Madura Mallige blooms between 6 and 7. What's the great difference between 5 and 6 and 5 and 7? At 5 o'clock, it's sunny. But at 7 o'clock, it is not sunny. Sun is already set. And at 5 o'clock, the wetness from that is taken out. And at 7 o'clock, the wetness remains. And it remains fresh. And because of this is a unique thing. This is a geographical indication. This is one of the best examples you can have on that. I hope that example was good enough to make the point. And if that is made, let's move on. Now let's move to the further understanding of that. It's a group right, as I said. It's a unique feature because all the other intellectual property we discussed were of individual or joint nature. This is a group right. All the Madura Mallige producers will have the right. They can share the right. And next one is it's a permanent right. There is no duration limitation like 20 years or 15 years. And next one is it has got an office in Chennai where you can register it. And the law dealing with geographical indication in India is GI Act 1999. We are jumping to the last item in the list. Let's look at that. It is trade secrets. Trade secrets is another intellectual creation. It's an intellectual creation which gives a commercial advantage. But the most important factor here is it is kept secret. The best example I can share with the audience is Coca-Cola. It is said that the formula of making Coca-Cola is kept secret for the last more than almost 1.5 century, since 1886. The advantage here is, as it is kept secret, as this intellectual creation is kept secret, a competitor is not able to offer the same taste or the same product, and that definitely gives commercial advantage. So that is based on intellectual labor and investment, and that's protected as an intellectual property. Let's move on with the understanding. Let's just read the further details of Coca-Cola. As per the published accounts, it says it contains sugar, crystal, caramel, and things like that. And read the second paragraph there. Mercantile 7X is the secret agent in Coca-Cola, and apparently remained a secret since its formulation in 1886. And that makes a difference. Let's move on. Now, you have got an example. You have got a list of trade secrets here. It's not just formulas that would constitute a trade secret. Trade secret could be an algorithm. It could be techniques and know-how, data compilations, business strategies. List goes on and on. Any information which is useful, at the same time secret, and which gives a competitive edge over a competitor. That's what a trade secret is. And behind that should be, of course, there should be intellectual labor. So with that, we now complete our discussion on intellectual property. It's a permanent right. We don't have a law in India as far as trade secret is concerned. There is no legislation, and there is no case law also worth relying on. So we rely on the contracts and things like that. So that's a position as far as trade secret is concerned. And that's it about it. Let us see the road which we traveled, and let us complete this. We started off with patent, then we moved to trademark, then to industrial designs, then you have copyright, then you have semiconductor chip protection, IC chip protection. I hope every participant is able to recollect the basic ideas we discussed in these topics. And then you have plant varieties, then you have GIs or geographical indications, including Aramulla mirror, then you have trade secrets. So this is the road traveled, and that's about intellectual property, and that's it from my side. Thank you so much. If you have anything to ask, then we have time for that. That's it. Thank you so much for the invitation.
Asha?
Hello.
Yeah.
Sir.
Shall we start introduction, Asha?
Okay.
Okay, well,
Students, if
yeah.
you are having any doubt, you may please ask our resource person, or you can use your chat box.
Yeah, and that's also welcome.
Before the students start, let me just want to comment on your presentation, sir. It is
you're most welcome, sir.
Yeah, it's mind-blowing, very wonderful, and I was really amazed by the way you are presenting things. It is highly useful to students as well as for the teachers.
Thank you so much, sir.
Thing I want to connect with you. One is that in the year 1987 to 90, I was in law college evening batch. So we have a connection there.
Oh God! Okay.
And I know your principal, Dr. Dataji Nair. I was very well known to that ma'am.
That's great. That's great.
I was in CUSAT. I did my MPhil and the PhD in CUSAT. I was staying in Sarawar hostel, and I was a very.
I was in Siberia.
I have good association.
Okay. That's nice to know. That's nice to know.
Yeah,
that's wonderful. That's wonderful.
Really wonderful. Very energetic. Very powerful. It is very informative for students. And I request my students to ask questions here. Any questions related to patent or copyright or trademark or IPR, it is a good time for it, because this topic is very important for economics students also. So please, students, please come forward.
Good afternoon, sir.
Please.
Good afternoon. Your name appears to be Kavya Madhavan. Because of that name, I noted it. Okay. Yeah, please.
So hope you're doing
Shoot your
good.
question.
Yes, sir.
Yeah.
So my question is, like India's rank has slipped, like despite the growth focused by the government, the efforts that the government has taken so as to support the so-called innovation, creativity. Like we have also had the so-called Kapila scheme that the government has launched so as to create awareness on IPR and all that for students. So my question is that India even today continues to remain on the US trade representatives like priority watch list of violations of
Mhm.
IPR. So what would
Yeah.
be a possible or an ultimate panacea that would come up from your side as a person who is well versed in the subject? Thank you, sir.
Yeah, what you said is right. It's really interesting to know that you've gone so deep into this. There is something called the 301 list for US, wherein US has got a law, and the US usually what they do is they keep a watch on people, watch on countries, which has a tendency to violate intellectual property or less protect or under protect intellectual property rights. Of course, we are in the list. But I would say India is a sovereign country. We have got our own interest, our own policies to make. Just because US has put us in a list, that should not make us, that should not hinder us from doing this. If we are sure that we are doing that within the framework of the international obligations which we have undertaken under WTO, there is something called as a TRIPS agreement. If it is done within the framework of the TRIPS agreement, which I believe it is, and if it is done within the framework of TRIPS agreement, we shouldn't mind whether it is in the 301 list of US or not. That should be the strong stand we should be taking. Our policy should be our national policy. And in 2016, we have got a national policy, a national intellectual IPR policy, which I think we should stand and we should go with that. That should be our approach. Thank you so much for the question.
Thank you, sir.
You're most welcome.
Okay, Kavya, or you got it now?
Yes, sir. Yes, sir.
Okay. And Lowell, sir, 6 of
Yeah,
our PG students are going to USA next year through a collaboration
Yeah.
with the Virginia Commonwealth University. I expect some questions from students of the students pursuing their course in Virginia Commonwealth University. Anybody from that group? Any questions? Anybody present? Only one question, please. Yeah. From first year BS students, first year BSc Mathematical Science. No, it's time to ask and clarify your doubts. Before you, a great man is sitting. Hello. From faculty side, make it more lively. No, I'm having lots of questions in my mind, in fact.
No, then shoot it.
No, that 2006, no, when we were having the seminar on IPR, the issue
Yes.
that was more was about the CD piracy. That time, Tommy Tachangari was one presenter. CD piracy was there. And who has the patent of turmeric? Is it with America or with India? And the Basmati was discussed loss. And I think
Yes, but that is
right.
Yeah.
These are the issues. But now situation is completely changed. Even after dental after
Now it's, we have a lot more higher level of awareness as far as intellectual property is concerned. We have got more laws. We have got better institutions. We have got more advocates dealing with that. We have got more popularity among people itself. So the entire scenario has changed.
Complete change. Yes, complete.
Yeah. From 2006. Yeah.
Okay. Anybody? Any other questions, please? Merlin, Anita, any questions, please? No questions, please. We are well versed in IPR, right?
Yeah, maybe that.
But it was a sweet presentation, sir. I really enjoyed it. From my heart, I'm saying.
Okay.
Yeah, one question.
Thank you for the generous words from your side.
Swati is asking some questions. Swati, please, Swati.
Sir, I don't know whether it's a right question. I have a small question. Is IPR is affecting the investments that are relating the multinational companies?
No, it is, sir, at least in theory, it is attracting or it is giving, it's incentivizing investment. Because in a way, a multinational company will not come forward to invest, at least theoretically, to invest their 100 crore rupees to develop a new product unless they are sure that they are going to get a return out of that. Nobody is going to do that. You are not going to do that. I am not going to do that. That's quite quite clear. So here, at least the assumption is this: this law is used, especially patent law or any other law for that matter, any other intellectual property law for that matter, is for the purpose of incentivizing, attracting a private company to come out something useful to the society, and for attracting that, we give them assurance that you invest, we assure monopoly for you for a limited period. That's how it works. That's how this legal model or business model works. And whether in fact it works in the way it should work is a different question to be addressed, but this is supposed to be like this. So, but your question is definitely very sensible. And thank you for the question. Good question.
Okay,
Thank you.
Sabi. Well, very good, Sabi. Very good. Any more questions, please? Okay, Asha, shall we conclude now?
Yeah.
I think there are no more questions. Asha, please.
Okay, hope there is no further questions from the student side.
Yes, yes.
Okay, now it's time to wind up the session, and it's my turn to bid goodbye and to say a few words of gratitude to all who are assembled here for the webinar. First of all, I would like to thank our principal, Dr. Sabuke Thomas, for chairing this event. Thank you, sir. I extend my deep sense of gratitude to our manager, Reverend Father Biju Joseph, for inaugurating this webinar. In the midst of his busy schedule, without any hesitation, he accepted my invitation. So once again, thanks to Reverend Father Biju. Next, I would like to thank our resource person, Dr. Lowellman. Dr. Lowellman is not a new face for Devagirians, just like what Father Anto mentioned in his speech. Last year, we were having a seminar on gender equity, and it is from that day onwards, Dr. Lowellman, though an advocate and professor of Government Law College, Calicut, slowly became a member of our family too. Such a simple and humble person who is always willing to deliver his academic knowledge to the young generation. I just made a phone call and everything was arranged within a short span of time. So no words to express my sense of gratitude to Dr. Lowellman. So on behalf of the Department of Economics, I extend my heartfelt thanks to Dr. Lowellman.
It's my pleasure associating with Devagiri.
Thank you, sir. Thank you so much. I'm very thankful to Reverend Father Anto Enche, the Vice Principal and IQAC Director of our college. Actually, this program is a collaborative effort with IQAC. Thanks to Reverend Father Anto for his constant support and cooperation. No words to express my heartfelt thanks to Dr. Sanathanan Vellua, HOD of our department, who can be addressed as the backbone of this event. Thank you, sir. Thank you so much. Next, I would like to thank all my co-workers, Dr. Shibi M. Thomas, Mr. Thomachan Ketty, Ms. Shiny K. Matthew, and Ms. Asha for their support. Last but not least, I would like to thank all my dear children, elder ones and younger ones, from research scholars to degree first-year students, who are actually the reason for the success of this event. With you, this event has become a hero, otherwise a big zero. So thank you one and all. Next, I would like to thank my helping hands, the technical wings, Mr. Vijay and Mr. Sharath, who were always with me in making this event a grand success. So before leaving, a big thanks to everyone. Now me, Dr. Asha Matthew, bidding goodbye to everyone. Have a nice evening. Thank you so much. Thank you.
Thank you, Asha.
So much.
Thank you, Asha.
Thank you
I
so
think
much.
the formal
My
function.
pleasure.
Yeah, thank you. The formal function is over. So let us make it little informal. I must say a big thanks to Asha, Dr. Asha Matthew, for taking all the pain. Even if it's a short notice, she will do wonderfully. So the main brain behind this is Dr. Asha Matthew only. And one more thing, I came to know about a new person Dr. Professor Lowellman. It's my time to introduce him to various parts of the Kerala colleges. Okay, definitely we will meet you, sir. Definitely we'll meet you. Thank you so much.
Thank you, my pleasure.
Thank you.
Okay, okay, thank you. Thank you.
Thank you. Thank you.
Thank you, Lowell, sir. Thank you so much. Thank you, sir.
Thank you. Thank you.
Okay, bye.
Okay. Okay.